Hello, my name is Jennifer Grady, and I'm an immigration attorney at the Grady firm in Southern California. And today we're going to talk about H-2A visas for employers that are seeking temporary agricultural workers. And this would be every year, the fiscal year October 1st changes. So this will be for the fiscal year 2025, which started October 1st, 2024. A quick background about me. I have been owner of the Grady firm since 2012, and we specialize in helping employers procure visas for workers, and that's everything from laborers like H-2A, H-2B workers to STEM degree holders and executives and managers. And we've been working specifically on the H-2B visa since 2018, so we've been doing that twice a year and have developed a niche and a lot of success in that. And then also we've been working on the H-2A visa, which is a little bit easier. And that is very similar process, but that's specifically for workers in forestry and agriculture. So for anyone listening, if their work does not fall within that definition, then you might want to look at the H-2B visa, which is done twice a year for October 1st and April 1st start dates. So just a disclaimer, this presentation is for informational purposes only and does not constitute legal advice, but it's just an overview for some issue spotting to let you know what this is about if it's worth exploring more for you. So let's get into what H-2A visas for temporary workers are. First, they permit U.S. employers and agents to bring foreign nationals to the United States for the purposes of filling temporary agricultural jobs. In order to qualify, the employer must have a place of business that's physically in the United States, possess a valid FEIN number, and have the ability to hire, fire, supervise, or otherwise control the work of the workers that they employ. As I mentioned before, the work must be agricultural labor or services such as planting, raising, cultivating, harvesting, or the production of any agriculture or horticulture commodity. So it's very specific who would qualify. The work must be for 35 or more hours a week, so it's going to have to be a full-time job. And most importantly, the work must be seasonal or temporary in nature and tied to a certain time of the year, like growing season, harvesting season, processing season. And it should be normally about 10 months or less. So close to a year, but not the full year. And if it were the full year, then it wouldn't be temporary or seasonal because it would be the entire year. So the period of stay can be up to the authorized period of stay, which is going to be on the labor certification, which is a form we'll talk about in a bit. And the classification may be extended for qualifying employment in increments of 1 year. So normally we have to apply for this visa every year. So I reach out to my clients at the same time every year. Are you interested in applying again? And then we get the process going. So the maximum period of stay in H-2A is 3 years. And if they've had it for 3 years, they have to depart and remain outside the US for at least 3 months before coming back as an H-2A non-immigrant. And important to note, if anyone was already here on an H-2B or an H-1B or an L visa, that's going to count towards that time since those are similar categories under H or L. Now, before we get too far into it, we want to make sure that the workers that you have in mind are from an eligible country. So the United States has on the books laws that allow people from these countries to come to the United States as an H-2A worker, and this changes every year. So this chart is based off the USCIS website. It's current as of today. And sometimes we do have people asking for someone maybe from Venezuela. As you could see, they're not on this list, so they would not be eligible. There are rare exceptions if you're able to prove that somebody might be in the United States' best interest. But really, it's going to be a lot easier just to pick somebody from this list. So as you can see, popular countries are Mexico, El Salvador, Guatemala. That's where the majority of the workers come from. But if for whatever job they are, if it fits as H-2A and they fit on this list, that would be the first step in terms of whether they would be eligible for this visa. So this is a multi-step process, and I have it numbered just for your comprehension. So H-2A and H-2B visas are very, very deadline heavy, deadline driven. You have to meet exactly the deadlines, or else it might prevent you from moving forward in the process. So the very first thing we do is file a job order with your state's state workforce agency. And so that's going to be specific to your state. It might have its own form or its own rules. And we have to file this job order within 75 to 60 calendar days before the start of the work. It's very specific. So at least 2 months out before that job is going to start, but no longer than 75 days before. And so we'd fill out a form, we'd file it in the Department of Labor's flag portal. And then in about 5 days, we're going to check back and do the next steps. And so they're going to review it, let you know if they need to make any corrections, and then you'd post it with your state workforce agency. So for example, in California, we use CalJobs. In Connecticut, it's Connecticut Hires. So that's something we'd be able to help you figure out. So then once that is ready and filed, then we have to do the most important document, which is the temporary labor certification. We also file that with the Department of Labor, and that is no less than 45 days before the start of the work. So if for some reason you were late in doing so, you'd have an extra burden of explaining why it's an emergency. But the easier option is sometimes to push that start date back, as long as it's consistent with your actual need. So if there's any deficiencies that are found, you will get a notice of deficiency within 7 days, and you get 5 business days to respond to that. So it's pretty common, I would say. Currently trending, the Department of Labor is actually more strict than USCIS, in my opinion. And so they're going to come back maybe with little administrative or little rules-based things, and often they're easy to fix. You can fix it in the same day, write back, and then move on to the next step. So once you do that and you get the notice of acceptance, we move on to the recruitment step. And so the point of this is the Department of Labor is like a gatekeeper, and they want to make sure that we're not taking away jobs from willing and able U.S. workers. So in order to do that, we have to do a recruitment process. And so the notice of acceptance will tell us what we need to do, but usually it is contacting former U.S. workers that are eligible for rehire from the previous season. So if somebody quit, then you would need to call them and offer them the job. And we also recommend you do that in writing, in email, or via mail as well. And then you'd make a chart of who you contacted, when and how often you contacted them, and the outcome. So we'd want to make sure we have a legitimate reason why they didn't accept coming back to the position. For example, they may have a job somewhere else, or they're looking for more money. But often maybe we'll get 1 or 2 people from prior seasons who do want to come back. And so then that would reduce the number of workers that you're going to ask for. Say you needed 5 workers and 1 wanted to come back, then we would update that to be looking for 4 workers. And then when we're done with this, we would file a recruitment report and a copy of your proof of workers' compensation insurance. So preparing and filing the recruitment report, we also do this in the flag system as well. And so we would put the names and contact information of all the people that we contacted. And then if there's any reasons why they weren't hired, we would include that as well. Once we get through all of the Department of Labor section, then we're going to move on to the I-129 petition. And that is what we would be filing with USCIS. And so then we would create a packet with the form I-129 that's going to have all the information about the employer and the job, and potentially the beneficiaries, depending if they're named or not. And we will also include supporting evidence about the company, showing that it's a legitimate business, that it's solvent, and any information about the workers if they're named. So there is a filing fee for this. This is the first point in the application where we have a filing fee. And if it's a large employer, which is 26 or more employees, the filing fee will be $1,090. Or if it's a small employer or nonprofit and we're doing named workers, it's $545. If it is a small employer or nonprofit with unnamed workers, it's $530. So this changes often. Again, we'd always want to be checking with the USCIS website. They have a very elaborate fee schedule. It's like doing algebra to figure out. It used to be simple, and then about a year ago, they in 2024, they changed the fee structure. And then now, in order to pay for all of the asylum cases that we're receiving, that fee has been passed on to the employers. So for a small employer or nonprofit, the additional asylum fee is $300, and for large employers, that fee is $600. Once that petition is approved, and it should be in a short period of time for the H-2A visa, but unlike the other visas, we don't actually have to use and pay extra for premium processing. But once that petition is approved, you take that approval notice, and then the individual workers are now going to do the individual part of the petition, which is them applying with the Department of State. So they're going to fill out a form DS-160. So we can help with that, or sometimes people use third parties to help with that. And they're going to fill out the DS-160, put information about them personally, their work history, a little bit about their family, if anybody is traveling with them, if they've had any visa denials in the past. That's something that you'd also want to figure out up front with someone. Occasionally people are denied a tourist visa if it looks like they are going to come and stay and work or overstay, and they may be denied, but we have had people successfully be approved once we have an approved petition and we bring the right documentation with them to their interview. So it's not necessarily a deal breaker, but if it's denied for a substantive reason, then maybe we'd want to look into that and perhaps choose a different candidate. So you'd file the DS-160 online, and then if the visa isn't waived by the consulate, they would come in and they would do a visa interview. We'd help prepare a packet to bring with them, do a Zoom video to prepare them a little bit, and then they would come in and do their visa interview. So several outcomes could happen. One is they can be told that day that they are approved. Two, they could be told that it's going into administrative processing. So especially if there was any denial in the past, the consulate's going to do a little bit more digging, or they could be told that it's denied, and you'd want to have them take home a paper with them that explains the reason that it was denied. If the worker is going to bring any family members with them, they would come to the interview as well. So as to the family for the H-2A visa holders, their spouse and unmarried children under the age of 21 can seek non-immigrant classification under H-4. However, family members are not eligible for employment. So often I would say most workers come by themselves, but if they did want to bring a spouse and children under the age of 21, they're able to do that. Now, one aspect of the H-2A visa that's a little bit different than others is that there is a requirement that the employer provide housing to the workers who cannot reasonably return to their permanent home at the conclusion of a workday. So, for example, if someone is doing forestry work and they're out in the middle of a forest, very far out, they may have a trailer or some other housing there where they can stay. And this housing needs to be ready 30 days before the start of need. And the SWA or Department of Housing might come out and do an inspection. And so the next page, I'll show you a little sample of that checklist. And if there are any issues, they might tell them these things need to be fixed before the workers come. And that's to ensure for the safety of the workers that it's a habitable location and it's compliant and we're not putting them in somewhere that's unsafe. So the housing reports must be received 32 days before the start of need. So again, it's very short. Once we get the prior steps, they're going to come out and check on the housing. So it is possible to rent housing or do an Airbnb, but that might require inspection. So again, that would have to be coordinated how that will work out with the timing. And so if the worker wants to live in their own housing, say, for example, they're bringing their family with them, or they want to stay with a friend or relative, you'd want to get that in writing. And then also the employers are required to provide 3 meals a day up to a certain amount, or free and convenient cooking kitchen facilities where they can prepare their own meals. So here is a sample. There is an official document. If you're interested in it, you can email me at info@gradyfirm.com and I can send a copy of this to you. But this is actually by statute, the different sections, so housing, water supply, waste disposal. So we can look at this before the appointment, and you can check on your own to make sure that you're going to get good scores when they come out and do the inspection. So transportation, again, a lot of the H-2A jobs are rural in nature, and so the employer must provide daily transportation between their living quarters and the work site at no additional cost. And it must be compliant with safety standards, insured, and operated by licensed drivers. So again, very regulated for the protection of the workers. So after we have an approval, that's time to celebrate. And then that is the time when you're going to be preparing their transportation. So you'll be, if they're in the continental North America, you might be chartering a bus to bring them to your site, or if they're from another country or the distance is great, you might be arranging their flights. So since the employer is responsible for transportation from their point of origin, so wherever they live, you're going to be getting them to your job site. And so the easiest way is to pay for their flight up ahead of time, but you can also reimburse them for that transportation. And then they are eligible for meals up to a certain amount, and that's by statute, per day. And then if there were any issues, like their flight was canceled and they had to stay in a hotel, you would make those arrangements as well. And so once they come and they start the job, really in order to be successful, you want to have an orientation. They're from another country. Often it's their first time coming to the United States. So you want to have someone there, hopefully, who can speak their language, can help them settle into their home, tell them a little bit about the area where they can go shopping, what things there are to do. That translates into more success. So there are employees that abandon the job, and often they might be lonely, they might be missing home, or they just really they weren't prepared for it. So it's in your best interest to make sure that there is maybe a mentor or somebody in the company that can help them with that transition. If an employee does leave, then you're required to notify Department of Labor within 2 days after the job is abandoned. And what is abandonment? After the worker fails to report to work for 5 consecutive working days, then you consider them terminated for cause due to abandonment. So really about a week after them not showing up, we need to notify DOL and USCIS of their abandonment. So for return transportation, if the worker worked at least half of the contract, so say they're going to work for 6 months, after working 3 of the months, then you would be required to pay for their return transportation. And let's see, and you can't take that out of their wages. I know that's a lot of question, is what can we do? So there's fact sheets that we would send you, and we really have to comply with those, and the record keeping requirements, at least 3 years, to make sure that you did the process completely. There is a lot of fraud. There are a lot of companies that don't do it correctly, and we want to make sure that you're not one of them. And so then once we're getting close to the employment date, we want to remind everyone what that last day is. Occasionally there is a short grace period up to 10 days that would be on their I-94. So once they come into the country, we'll be able to know what that date is. But if you want to have them come back, you definitely want to have them leave on time and return to their home country. And ideally, if it went well, we want to keep communication with them so that a few months ahead of time the following year, we can confirm that they'll return, because it's definitely easier to have that recurring relationship and people that are already familiar with your business and coming to your city. So if for any reason the H-2B doesn't work and it's not something that you're qualified for, we have other options. One is the EB-3 green card, or if you did find someone that you like and you want them to come back permanently, we can do the EB-3 green card application. Currently, it's taking about 3 to 4 years after we do all the steps. It's very similar to the H-2A, but over a much longer time frame. And a lot of that depends on Department of Labor processing times. But this could give them a green card and they could work for you indefinitely. And after 5 years, they're eligible for citizenship. They can also bring their spouse and dependents under the age of 21 as well under this process. So if it's someone who's really been loyal and a great employee, or they're a family member and they've been working for you, this is an option. We also have the H-2B visa, which I mentioned earlier, and we have an entire page on our website about that. We're currently working right now in October for an April 1st start date. Again, I like to say it's at least 6 months in advance for a 6 to 9 month visa for the H-2B. So just a little bit more about our firm and what we do. We really focus on visas for employers, but in that context, we also help with employment issues, business advising and contracts, and really everything that the business owner would need to grow their business. So please go ahead and follow us on Instagram or Facebook or LinkedIn. And we have a very active blog at gradyfirm.com and a monthly newsletter that you can sign up for there. If you have any questions, please feel free to reach out to me. And you can always book a consultation on our website at gradyfirm.com. Thank you so much.